Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for January 26th of 2026. Brad, go ahead.
First of all, thank you to all the first responders, including you, because I'm in Florida now. So, including you who are sitting through probably horrendous winter conditions and having to get to calls and having had to get to calls
I
through that.
enjoy it. Personally, I enjoy it. So
You probably take a snowmobile or a six-wheeler over to
we
get
have tractors and we have four-wheel drive pickups, and
it.
we're dressed for it. It's not a big deal.
Yeah, well, those who have highways and throughways are getting hammered,
Mm.
just because it's such a difficult response. Okay, in any event, let's go to North Carolina, where I hope and pray that these allegations are not true, but there's a line in here that I think is really important for us to talk about. So what we have is we have a battalion chief who has been arrested and arrested by the police and by his agency has been placed on administrative leave. This is the Matthews Fire and EMS department. He was charged with setting fire to an unoccupied commercial building earlier in January. That's about as much as we know, except something sparked my concern where they said he's placed on administrative leave pending an internal investigation. And like you, I'm guessing when I see those words and criminal activity, Garrity gives me chills.
Oh yeah,
Right?
yeah,
I
yeah.
mean, they could say the wrong thing, they could promise the wrong thing, they could not say the right thing. There are so many ways to screw up the DA
Hmm.
prosecution
Hmm.
through what they say, don't say, ask, don't ask. That I worry. I don't know about you, but I worry every time I see someone doing internal investigations in criminal matters.
Yeah, if they're not properly trained and they don't understand Garrity, and Garrity's going to be limited to work-related actions. So it's got to be work related. Now, if he was on duty or if it was somehow connected to work, now you've got that nexus. If it's got nothing to do with work, then Garrity doesn't apply, but the firefighter has the Miranda rights not to answer questions. So it's an important distinction, that it's a nuance and it's not well understood by even attorneys. Never mind, firefighters and firefighter investigators. A lot of attorneys don't fully understand Garrity, but it's got to be the term that the U.S. Supreme Court used way back in 1968 was it must be specifically, directly, and narrowly relating to the performance of their official duties.
And when I see internal investigation, I
Yeah.
start to wonder, well, it I'm assuming they assume this was related to work. Maybe he had his chief's vehicle, maybe he was on
Well,
duty.
you can still be disciplined for off-duty actions.
Of
It's
course,
just
but
that
how do you investigate something that didn't happen in your agency or while your employee was on
well,
duty
we
and
do it.
happened
We
out in the
do it all the
community?
time. We do it all the time. It's just the distinction now is that the easiest way when somebody's accused of doing something wrong, the easiest thing to do, the simplest thing to do, and by the way, the simplest thing to do is usually the wrong way, but the simplest thing to do is call the person in and ask them questions about it.
Right.
Okay? That works as long as there's no, it's probably not a good idea, and we certainly don't recommend it. We usually recommend doing it the right way, which is the hard way, which is interviewing all of the witnesses and interviewing the accused last. But when you call the firefighter in, if it's work related, if it's SDN, specifically directly and narrowly relating, the
Right.
firefighter has to answer the questions. If the employer orders them to answer questions, they've got to answer the questions. If it's not, then they have a right to remain silent. So what you do, you call the firefighter in and they say, assuming that they have good counsel, the attorney's going to say, we're not answering the questions.
Yep.
Okay.
Yep.
And they're going to say, well, you're going to be terminated, or you're going to be disciplined, or whatever. And said, well, I have a right to remain silent because my answers could implicate me. And I don't even have to tell you why it could implicate
Right.
me. But bottom line is, I'm not answering your questions, and you can't hold my silence against me.
And the problem is they don't necessarily know whether I don't know what they know,
Mhm.
right? But they might
Mhm.
not necessarily know whether this happened on duty or not. They may be thinking about Garrity protections or not. And
Right.
that's all that concerns me. And look, I've had a situation where we got a video of one of my clients volunteers. They're wearing the jacket of the volunteer and they're shoplifting, right?
Mhm.
Okay, there's an internal investigation we could do. And, the person's shoplifting in uniform. So, okay, I suppose that's an internal investigation of an external matter. But
It
something
still
like
is work. You're on duty. It still is work related.
you're in uniform,
Yeah,
right?
it
So,
still is. It's,
I'm okay with that, even if they were off duty, just wearing, their shift ended and they're, in uniform and shoplifting after. Again, I'm good with that because we're just reviewing a video. But
Mhm.
what exactly are you doing to investigate an arson? Now, if you have arson investigators, you determine it's arson, but usually, in my experience, it's the police who investigate who did the arson.
Yeah. Well, some places have sworn arson investigators. They're sworn, they've been to the
Right.
police academy or some portion of the police academy sufficient for them to be sworn in as law enforcement, and they have arrest powers, but it's limited. They're usually limited to fire-related types of crimes. But here's one way to kind of think about Garrity and kind of take a step back is the fire chief has the ability to grant immunity
Right.
to its employees. When would it be appropriate for the firefighter to grant immunity? If you've got a firefighter, and these are real life cases, you've got a firefighter who is somehow possibly involved in a homicide off duty. Should the fire chief have the ability to grant that person immunity? No,
Right.
no, that's crazy. Okay. You got another firefighter who is involved in off duty drug dealing. Should the fire chief have the ability to grant immunity? No, no. But when things are related to work, whether it's theft of drugs from the med unit or other types of things, there's a decision that has to be made. And there's consequences to that decision. But if the chief and the investigators order the firefighter to answer questions, then Garrity immunity is going to attach to the firefighter's answers.
Yep.
So it's, and I think when you look at it from that perspective, Garrity makes a lot more sense that it's really the authority of the chief to grant immunity that's going to dictate what is specifically directly and narrowly and not.
And there are consequences that the listener should know for when you screw it up, when you mess it up. And some of those consequences are not
Yeah.
horrible. Maybe it's just, okay, everything you learned at the interview, the DA can't use. Fine, that's
Right.
not the worst thing in the world. Others may impact the DA's
Well,
ability to
there's yeah,
prosecute.
there's two states, and you and I know the difference between derivative use immunity and transactional immunity. Okay, there's two states, Massachusetts and California, where it's transactional immunity.
Okay, and explain that to the viewer so we don't have
Yeah,
to.
so derivative use immunity is that you can't use the answers in any way. You can't use the answer, you can't present the answers that the firefighter gives to questions in court, nor can you use them to get a search warrant, to get a search warrant for his, maybe put a wiretap on his house or go in his locker and search. They can't use it at all. And if they do, it's going to be subject to the MAP v. Ohio exclusionary rule. Okay, so it's pretty basic there. Transactional immunity is that if you admit to an offense, you can't be charged with that offense.
And that's the big one, right? I mean, that's
Yeah, and I don't know what the people in those two states are thinking by having that, or what the judges are thinking
right.
by requiring that. But
But
48 states, I think, have it right, and those two states have leave me scratching my head.
But people still have to be careful in the other 48 because fruits of the poisonous tree. If the
Oh yeah,
employer, right, the employer learns
yeah,
something that and it violated the, giving their rights, and everything, they violate Garrity, they violate, in some
yeah,
sense, Miranda, and then they tell the police, hey, here's what we learned, you should do this, and they get a search warrant based on that information.
yeah.
Goodbye. So that is
That's why
all
whenever,
nervous.
yeah, whenever we're doing an investigation, it's important. The investigators are trained, number one, and they've got to be looking for possible criminal offenses. And where there are criminal offenses, we don't want to interview the accused firefighter until we've had a conversation with the police and the police are okay with us moving forward. Because we don't want to do anything that's going to undercut theirs. Now, sometimes you're not even going to see it coming. I was teaching a class in Las Vegas about a year and a half ago, and they were one of the fire departments there was investigating why it took an EMS unit 20 minutes to go 5 blocks. you know.
Right.
And, it's a very, very common thing. So they call, and the unit was in quarters at the time, and it took them 20 minutes to go 5 blocks. So they interview the officer, and they do the standard. You got to answer the questions, blah 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 blah, and he stopped to buy drugs on the way to the run. No, like foretelling that was going to be a possible issue there. But so sometimes you're going to be surprised. Okay?
Yeah.
But
Yeah.
I will tell you, I thought you and I were going to have a discussion about what happens if the person was charged under the wrong statute, because the press release on this, both the news media and the issue,
Right. Use
the
the
media
definition section.
issued, that they cited, at least they cited in the press release, the wrong section. And so that would be grounds for a reversal or at least dismissal of these charges, or have to amend the
Which
charge.
they'd have to be amended.
So,
That's right. That's what
yeah,
all would happen. They'd amend it, and that assumes, as you
yeah.
said, the news got it right. They just didn't,
Yeah, but this,
pull
if you
something.
if you go to the Facebook page of that police department when they issued it, the police department cited the wrong statute. So,
Yeah, maybe they put at seek, maybe, right, means and
well,
continuing, but
yeah,
who knows?
it's a pretty. There's several at seeks there. You're talking about the overall chapter. I would have said it's section 14-58 at seek. They went right to the first paragraph in that one, paragraph 1. So I don't know.
Yeah.
We'll see. But I thought that was an interesting thing. You can't screw around with criminal charges.
No,
You've got to
if
be
the tickets are
perfect.
wrong.
You have to be perfect.
Yep.
So
All right. Well, okay. So let's go to FDNY. Now, this case we've covered before, which is really interesting.
we have.
And I'm going to tell you, honestly, I'm not sure whether I don't believe the plaintiff's side for a little bit. So here's what happens. This I think it's a woman who's representing herself, said that she makes a call, and this part we've covered before, but I'll explain to everyone why. She makes a call to the housing department or something, and she's complaining about things, and she makes the mistake, perhaps, as you could see, somebody getting frustrated, angry, doesn't know how to vent it, right? She's having a dispute with the New York City Commission on Human Rights. And she says
over city housing. So
housing.
she's really having a battle with the housing, but she goes to the Commission on Human Rights to help her with the housing.
Right. And don't forget, normally in New York, being a very liberal employee protective and individual protective versus, corporations, right? They're more on the side of the individuals. So this is the entity who would have her concern, most likely, had she been treated badly. She says in an email, "I'm going to kill myself if this doesn't stop." Now, look, I parse things out. It's not "I'm going to kill myself," period. It's if this doesn't stop, right? So somebody, presumably New York City Commission on Human Rights, is concerned about that, which answers my question of, okay, do I agree or disagree with the city being concerned about her? Look, if the Commission on Human Rights is forwarding the email, they are at least concerned. They forward it. Police officers, FDNY, EMS, detain her. They don't forcibly transport her, but she complains, she alleges that if she was afraid that if she didn't go, they would forcibly take her. So, I get it. So she goes with them. She sues, and we already covered this, so I won't repeat all of it, but her first lawsuit is dismissed, but she's allowed to replead. And that's usually a gift, probably, as we said on that podcast or that show, that, it's a gift that courts do to pro se plaintiffs because they have no attorney. They say, we're going to give you another bite at the apple. So this time, she sues individuals. She's alleging unlawful imprisonment, unlawful search, retaliation, disability discrimination under both federal and state laws. And in short, the judge dismisses everything but one, right? And that one is really interesting. So as to the individual FDNY defendants. The judge says the amending complaint really doesn't specifically allege any action that they took other than they were there. So they're out. And that makes sense. And she would have had to say they were staring at me in a way to attempt, to force me to go, or they grabbed me or whatever. I don't know. But really the complaint's about the police, right, threatened her to go. So that's gone. But here, which is really interesting, the court denies the city's motion to dismiss on the 1983 claim for unlawful imprisonment. Now, everyone should understand that's not a big deal. A motion to dismiss, she just has to plausibly state a cause of action. She just has to put forth facts that she could win on. And the judge says here, the allegation that she was detained and transported for a mental health evaluation without sufficient justification is enough, right? Especially here when she says, well, this is how the city does it under Monell. They always do these types of things. It's an unwritten protocol or unwritten policy. So they keep this and they allow that to continue. Now, again, all she had to do is plausibly, relay enough facts that could justify this. It doesn't mean it happened, but here's the problem. The city doesn't, the city's a government agency. They have lawyers and, who do this stuff, not like they're paying their own attorneys other than their employees. But this now becomes a fact-specific issue. And a jury in New York City, where they are known by plaintiffs' lawyers, they are known to be very friendly to certain allegations. This is one, anti-police. This is one that if I'm the city, I'm thinking, a jury's not going to look favorably on this. True or not, I would be worrying. Yeah. Doesn't mean she's right. It just means you don't want to be in front of a New York City jury on this type of thing. So.
Interesting. Yeah. I mean, I think in my database, I should have run the numbers before, but if you look at the number of times fire departments are sued for not transporting somebody when they should have, this is one of maybe 3 or 4 that I have of being sued for transporting somebody against their will. It's kind of like man bites dog. It doesn't usually happen. It can happen. Theoretically, it can happen. Here's an example of it happening.
These ketamine cases, we have a lot of it, right? Yeah. But that's a little easier. We inject you and take you, or we handcuff you and take you. Here we stood near you.
I think for the medics out there that are worried about, should we transport, should we not transport? If you're in doubt, transport, and these are relatively rare. I understand the jury may not like police at the moment. Things are kind of anti-police, especially in states like New York. But I think the argument is easier to say we felt the person needed to go. Versus, we really didn't think they needed to go, and then you have a corpse, and we're dealing with that. So,
but I got to tell you, over 30 years, I try to replay how this stuff affects my own past, and I can't tell you how many times I've told somebody like who might have been drunk, who might have been something, and I said, "Listen, you can go with us, or you could go with them, the police," and they choose us. Yeah, and I'm thinking. Yeah. Was that, I don't think that's coercion. I think that's saying exactly the opposite.
Well, especially when it's truthful, and very often it is truthful that, you can come with us and go to the hospital, or you're going to get arrested now.
Yeah. Doesn't mean you're not going to get arrested once you get to the hospital, but initially go by ambulance or go by police car, your choice. And I'm curious whether, a court would interpret that statement that I think many of us have made, including myself, as being coercion to go. But, it's no different in my mind. And I'm going to where you're talking, nobody watching this should be worried about these facts, right? Because that is what a patient refusal is. When you say, listen, we're going to explain the risks and consequences of you refusing, that's not coercion. That's enlightenment, right? Mm-hmm. We're telling you what could happen if you don't go, what the risks are. So, as long as you're telling people, listen, I really think you should go because of these risks, that's good. Telling someone, I think you should go with us because we're going to arrest you anyway. I don't know. I whatever it is, but I get her I get her thought, I guess, but I don't agree with it. But and ultimately, I think she'll lose, especially because the police got a report from someone. They're acting on a report, nonetheless, from a very credible city agency who she contacted. So I don't think she loses. I just think I don't want to be in front of a New York City jury on this question. Okay, let's go to Colorado. This is the most interesting case. And I got to tell you, this is going to be on my list for the end of the year, unless we see anything else come out of it.
Yeah.
But this is huge. And I don't know if you know, before I get into the facts of the Colorado case and even tell people what we're talking about, do you know when the PFAS danger came out? PFAS in foam specifically. When do you remember when that was? Because I'm thinking it's
I think that's actually part of the litigation, and the knowledge by the chemical companies was there from day one.
Right, but fire departments.
The fire departments, I don't remember anybody talking about this till maybe 15 years ago, 10 to 15 years ago.
And that's critical for this issue, as far as I'm concerned.
Yeah, I mean, I remember salespeople. We had one of the guys was actually a firefighter in Providence, but he was he worked for he was selling fire protection equipment, and and I've talked to him since then. He said the same thing, that he was told it's like soap. It's like soap, and we would literally use it to every Saturday we scrub out the station, scrub the floors, and when the stuff was over 10 years old, it's just sitting around, so we'd use it as soap. But we were told it was nothing different than soap.
I have pictures of me covered in it.
Yeah.
Which now I'm really fearing a little bit.
We had a tank of it, about I think it was a 20-gallon tank, and all the engines. It was on the driver's side rear.
40-gallon foam.
And every part of your shift, part of your inspection every day was to put your fingers in the tank to see if it was full, because you had to reach in the tank, and we did that every day as chauffeurs. So
with that background, here's what the lawsuit is, and I think the timing to when the fire service truly had knowledge, because the chemical company should have given it to us. So
yeah, and I'm thinking they made a mistake by suing Denver. Why are they going
100%.
after the city? They really need to be going after the chemical companies.
Right. And I'm assuming, and again, I'll tell everyone what's going on here, because most people are scratching their heads, but I'm assuming they'll implead them. They'll bring them in as a third party, right? I would. And maybe that's the way they want to get to them. Maybe it creates a federal issue. I don't know. In any event, so here's what we got. We got a Colorado water district who's suing a Denver fire, is it the city of Denver? I don't know.
Yeah, the city of Denver.
Over PFAS contamination that very simply happened, they say happened, as they're using a training facility, and it was washing into the drinking water. It was washing downhill, basically, into the drinking water. They say that they did a lot of testing. This has been happening since 91, which is why I say, yeah, but we clearly did not know about this. Chemical companies may have, but we didn't know in 91. There's nothing that says, watch your, foam, because we all thought it was dish soap. And now they're suing, under CERCLA, the Comprehensive Environmental Response Compensation Liability Act, the federal act that requires you to clean stuff up. Also there's some Superfund stuff, et cetera, like that related. In any event, here they just say the groundwater beneath the training facility has been contaminated, drank into the it got into the drinking water. They had to clean it up. It was very expensive. And now they want the fire department or the city to pay for it. And I get it. I get the water, right? The authority there. It's not their fault, I assume. But it sure as heck isn't the fire department's fault. They said that the samples were collected in March of 19. Well, so what? Right? I don't know how long it's a forever chemical, but I don't know how long, if it occurred 20 years ago, would it still show? I don't know. But in any event, I'm presuming they're going to implead the chemical companies who they bought this from. And that's how the, water, because, and I'm thinking about this, the water company had no direct relation to the foam chemical company. So maybe this is how they intend to get to the chemical company.
Privity, they're not in privity.
There's no privity of contract. They didn't buy this stuff, right? Yeah. And so they were indirectly harmed. But I think maybe this is just a tact to get the fire district to say, we agree, we would be liable, but It's
I
really
think
the
there's plenty of others out there that are suing these companies that are not in privity. And that term, just so you know, when we say privity of contract, if Brad and I have a contract, we're in privity. We're members of the contract. If some third party, let's say John Murphy, wants to complain about something, he's not in privy to our contract. So
and the
that's
way they get around it is the stream of commerce argument, right? So in a car, think about stream of commerce is this way: I make the brakes, the brake pads that go into your car, but GM, you make the car and you sell it to somebody. As a brake pad manufacturer, I never sold those brake pads to, right? So it's the exact same thing. And what the law has come up with is called, well, yeah, but you put a product into the stream of commerce that then gets used, you're liable to the ultimate, to the end user. I
or the
would
victim.
say that is how all the other places are getting around it. I don't know. I'm guessing. But
Yeah, I guess. But these cases now have all been sort of routed down to the U.S. District Court in South Carolina. So they're handling, I don't know if that's a slow district court, if that's why they gave them to them, but there are literally thousands of cases now pending down in that southern the U.S. District for South Carolina.
okay, let's go to Florida,
Yeah.
where everyone needs to watch the video on Curt's website. And by the way, just to jump back to things, everyone should be taking Curt's Garrity course too, because where these things always come up, right? Where there's a possible criminal issue. So Curt, you offer a Garrity course. I don't know how long it is, but people should take it.
Well, I do a 3 to 4 hour webinar on it, but we cover Garrity in the basic discipline class. That's a 2-day class, and then we have an advanced discipline class, which is again 2 days, and we thoroughly cover Garrity in the advanced class. So whether you take the webinar, we covered a little bit, about an hour or so in the basic class. But it's complicated and it's not easy, or it's not hard. It's easy to get yourself in trouble. It's not hard to get yourself in trouble. It's you gotta be on top of this. So.
And pulling those two terms, being on top of somebody and it's not hard to get in trouble. Here we have because as people know, in Marion County, it's a couple of hours above me. I drove through it last Thursday. It's very rural. It's a very rural area. Not that has anything to do with this, but this is where three male firefighters, and then a woman who took the guy's phone. So technically 4 people, depantsed a probationary recruit firefighter. Look, he's like my size. He's skinny. He doesn't look that tall. He's not a massive guy. He looks like, he's, I don't know, 5 foot something and skinny, right? So he's not going to fend off 3 people, who jump on him, pull his pants down, whip him with a belt. These are the allegations. The woman is alleged to have taken his phone from him. He's screaming for help. No one comes to help. And then they waterboard him. And, people should be using that term loosely, because I say this there, and I was going to look it up, and then I'm like, I don't feel like having the FBI visit me or anything, but there is a technique to waterboarding. And it's not just pour water on a towel. Right? People who do boarding, and I know some who've done it in the conflicts overseas, they are trained to waterboard. And it is a art, it is a skill. I'm not saying it's good or bad. I'm just saying you don't try this at home. So whatever term you want to use, poured water over a towel in his mouth. He says he's drowning victims, and I'm a near drowning victim from a rescue a while ago, have nightmares. So this guy probably is having nightmares. My nightmares are me getting swept under a bridge. His, are probably something horrific. So I'm sure he has PTSD. In any event, he's in his probationary period. I would say he's probably the most secure probationary member ever at this point. I don't think he could do any wrong that would get him fired.
Well, he's up against it. You gotta. I agree with you on that. The city doesn't want to, but the problem is the other firefighters are upset with them for creating this big problem, for causing. So a total of 10 firefighters were terminated, 4 facing criminal charges, and the Brotherhood is upset with them.
And we shouldn't shame the victim. I know that phrase is used.
I got it.
In any event,
And
he's now commenced. The whole story is he's now commenced a civil suit, and I would think he would. You watch it. He's visibly shaken, less visibly shaken than I probably would be, admittedly. But he's been dealing with it. But some of it he can't even talk about. But you could watch the video. Everyone should watch the news video on him.
as I watched it, all I could think of was something that has been in my forefront, trying to understand the distinction between friendly pranks, friendly hazing, harassment, the kind of hot, I don't even know how to explain it, hard love that we show each other in the
we
fire
had an
service,
example.
okay, versus bullying, okay, and there are no bullies that say I was a bully. It just doesn't happen. It's just like, but when you objectively look back at it, you say, oh my God, these guys were bullying this kid. And I'm sure if you interview, and I think they have some of the police interviews on the video, they thought they were just treating them with, tough love.
Which would be hazing, not bullying. But
Well, bullying comes from a power differential, and this is where we've got to be very careful when we're dealing with new members, because there's a power differential that is inherent just in the fact that you're a tenured member, you've been there, you're a senior firefighter, and a lot of times even chiefs. I was teaching the class last week down in Clearwater, and there was a question about, well, a captain can't fire anybody. No firefighter should be worried about a captain firing him. Well, go back to your first day in the firehouse, and you're brand new and you're looking up at a captain. Yeah. I mean, a captain has authority, they have tenure, they have experience, they're in a power differential from you. And so, again, this is a new kid, and, it's unfortunate. I feel bad for him. I feel terrible for the organization. Okay. But I think the better we get at this, and my approach to this whole discipline area is, I want to find out that this stuff is going on way before we end up on the news over something.
Because this is a culture issue.
Intervene. This is not the first time this kind of behavior has happened in this department or at that particular station. If we can find out about it and get it to stop, maybe even without disciplining anybody, or maybe with brief suspensions or whatever, we never get to this big scandal like this. But if we look the other way at it and say, I went through it too, and you're setting the stage for this to be four people facing criminal charges, 10 people losing their jobs. Crazy.
Yeah. And I do want to say, if you are a victim of bullying, you should be reporting it. You got report it before it gets too bad. And you're in a hard position, right? If you can't talk to the people who are doing it, if you can't talk to the lieutenant captain above it, I know nobody wants to report it. But if you don't react.
And I do want to also say, and I'm trying to be fair to everybody here, okay? There are people that if you break eye contact with them, they're going to say, he's harassing me. He's not being fair to me. He doesn't like me. I mean, the slightest little thing, they're looking for some excuse, in particular where somebody, I'm not saying anything about this kid, but people who are low performers in the organization, and they're looking maybe for an excuse by why they're not performing the way they should. And they're going to say, I'm being picked on, I'm being harassed, I'm being bullied, when objectively they're not. That's another problem too. So again, there's a balance, and how do we strike that? That's the challenge. How do you strike that balance, and stop the bullying when it's actually happening, and not give fake victims a weapon that they can use because they can't deal with their own lack of abilities.
And then, you get into, and we've covered this case about 2 to 3 years ago. I believe it was a woman who forgot to bring some of her gear to a structure fire. So she held up the crew, right? She couldn't go in. So she left them short. And when they got back to the station, they ran her gear up the flagpole and said, there's your gear. And I actually liked that, because from a legal perspective and a teaching perspective, I didn't think that was the worst thing in the world. We didn't destroy it. We didn't ruin it. We said, there it is, go get it. And she's not going to forget that. Now, in truth, do you need that internal, code red, so to speak. You need that internal punishment to cause someone to remember it. No, I'm pretty sure she's going to remember never to forget some of her gear without you do it. But that's better than this. So maybe there's a line somewhere. And I'm not saying that's totally appropriate. I just,
it's hard. It's hard to draw that line between what's appropriate, what's not.
And the answer is talk to them, counsel, right? We can counsel without literally beating it into them. But I don't think this was hazing. This wasn't teaching. This wasn't hazing. This was just pure, as you said, bullying, which is not hazing, which is not teaching, has no valid purpose other than to make us more powerful than you. Yep. Okay. So, but you'll see this settled. The problem is this, by the way. I didn't see, because we don't have the copy of the lawsuit, right? We just I don't think on that.
The kid hasn't filed a lawsuit yet.
Oh, he just says he's suing?
He's threatened it. I don't know if he's got an attorney, and they said the lawsuit is coming. There's a couple of things in those videos, kind of going in different directions, but the fact that now it's up to 10 people that have been terminated, and
then you get into, listen, when it's one or two people, maybe it's not widespread. When it's 10 people who are terminated, now we have a culture issue. And when I hear a culture issue, I think a lawsuit for lack of supervision, lack of training, right? And the reason this person would need that is because these firefighters got no money to pay these type of damages. Maybe 10 of them come up with some money each, right? But any plaintiff wants the department on the hook because they got the money. So now you have to allege you knew about this culture, and that'll come out through discovery. And then all the dirty laundry is going to come out. And all the people who quit before, got fired before, whether justifiably or not, they're coming out to tell their story. It reminds me of on Independence Day when the aliens finally invade and the guy's like, I was abducted by aliens, I told you. And that's who, in my experience, comes out during discovery to say, I told you they were, harassing and bullying me. This is a culture. It's tough for the department. The department's, as it should be in this case, but it's going to be very tough for the department when he sues or if he sues. Okay, lastly, this is interesting, and this is so sensical, not nonsensical. This makes so much sense. So what we had is we have a lawsuit, right? And the lawsuit has two parts to it. It says the employer, a fire department, and this is brought by a captain, the employer discriminated against me, part one, and then two, and the employer failed to prevent discrimination. Well, think about it. You can't fail to prevent something that never happened, right? Right. So you can't say they didn't discriminate but you failed to prevent the thing they didn't do. Yet that's what the jury found. On two questions, a jury found that there was no discrimination, but you failed to prevent it, then award $700,000. As we get to the appeals court just said what I said. It doesn't make sense. So if this is the end, now, by the way, this was a 9-week trial. Now, I've had 2-week trials. They're brutal. You don't sleep. You get no other work done. Your firm, if you're a small firm, is shut down or whatever. You are not going back after a day of trial. And, so 9 weeks, you better be a big law firm to handle a 9-week trial. But nonetheless, this could go back to trial. And oh my God, 9 weeks. I don't know why it would justify a new trial, however, and that's part of the question.
Well, the judge ruled a JNOV, and I think it's worth us explaining exactly what a JNOV does. But what he did was in the alternative, because the city filed two motions, motion for JNOV, motion for a new trial. Yeah. And the judge granted the motion for the JNOV, and he conditionally granted a new trial in the event that the appellate court reverses his JNOV. So either way, at best, they're going to get a new trial. But as of right now, the case is over unless it's appealed.
Right. I mean, for the reasons we stated, it just doesn't make sense. You can't say you failed to prevent something that never occurred.
Let's talk about a JNOV. JNOV, when a jury makes a factual determination, remember the judge makes decisions of law. The jury makes questions of fact. They decide questions of fact. So the jury found factually that he had not been harassed. He had not been discriminated against, so there was no discrimination. They also found that the city was guilty of not preventing discrimination. So,
And they award
and they
700K
awarded
based on that.
700. They awarded 700,000. Now, whether the jury didn't understand or whatever, bottom line is that's what they found. And the city filed a motion for what's called a judgment notwithstanding the verdict. In other words, that there's a number of reasons why a judge may throw out the jury's verdict. One of which is the facts. No reasonable jury could have found on these facts that the way the jury ruled was what happened. Okay, it's not what the judge said here. The judge found that the jury's verdict was inconsistent. That you can't find that there was no discrimination, and then, as Brad said, then you failed to prevent discrimination. It's just it's inconsistent, and for that reason, the judge granted the city's judgment notwithstanding a verdict, which is essentially it's the same as a verdict in favor of the city.
And I don't understand how that could happen, because you don't see this on TV, but there's always a day, at least in my trials, it takes half a day and a lot of research, where we have the jury questions, right? And the judge says, here's the instructions I'm going to read the jury, and then here are the jury questions. And a lot of times it's if this, then that, but if you answer no here, stop. So I don't understand how.
I do.
Right.
I do. You know, I went to a continuing legal ed, one of the best continuing legal eds I ever went to. It was a day-long continuing legal ed, and it was a jury trial on mock facts. And they actually took jurors from Superior Court. They went with a judge, a Superior Court judge, and it was on the stage. And there was probably 200 attorneys in the audience. We were a big amphitheater, and they did a civil trial. And then the jury went into deliberations, and there was a video link to the jury deliberations. It was unbelievable. And the judge I thought the judge did a great job of explaining. I remember the attorneys on both sides, the plaintiff's attorney, the civil attorney, said, now remember, this is a civil case, so it's the fair preponderance of evidence standard. You don't have to prove beyond a reasonable doubt. So both attorneys said that in their closing. The judge, in her instructions, said that. Could not have been clearer. They get into the room. The first thing one of the jurors says is, don't forget, they've got to prove it beyond a reasonable doubt. and the whole audience was laughing. Like, we're like, you got to be kidding. And then it was a motorcycle car accident case, and the woman who was driving a station wagon hit a guy on a bike. She didn't see him coming. And so they awarded, and they went through the calculations of what they're going to award the motorcycle guy, right? And then old woman on the jury, she says, now wait a minute, I know we're going to give the motorcycle guy 1.2 million, but what are we going to give that poor nice little girl who was driving the station wagon? And we're like, you gotta be kidding me.
Yeah.
Like,
yeah.
So that opened my eyes to what is really happening in jury trials. Okay. And you can give them the clearest, these instructions could not have been clearer.
But the judge should have stopped it.
The judge,
thank you for no.
The judge is sitting with us. Now she's on stage and we're all watching this on a screen, what's going on. And the judge is going like this.
That would be awesome. I would love to see that. I would love to.
Oh my God. It was honestly, it was about 20 years. It was the best continuing legal ed class I ever went to. But and that was an actual jury. These weren't actors or anything. They were people who were basically on the jury list, and the judge took 12 of them. And
yep. And I got to tell you, that is kind of what supports my comment earlier in the show that, I don't want to be in front of a New York City jury. You normally don't always want to be in front of any jury because you don't know what is shown that has an impact on them. And the only thing you could do to practice, which I would always recommend, is, run your case through a group of individuals who you don't know, right? Mm-hmm. And so you see how they react to things, because how we think of things, we're biased. You can say I'm trying to evaluate the facts neutrally, but if you're involved, you want your client to win or lose, whatever, you can't be as neutral as a group of jury members. But to your point, they're unpredictable.
Yeah.
And that's why if people have lasted this long in this show, that's why at least my comments are: do you really want to go to a jury? This is going to settle. No, you just don't know. Anyway, that's it for today, Curt.
All right. Yeah, that's it. It was a good week. And for those of you who are still with us, thank you. Please, if you can help us, click like and subscribe and share. Let other folks know about this. And just a couple of points that I wanted to make personally. I have worked with Amazon to put out my new book. Managing disciplinary challenges in the fire service. So that is, available on Amazon. I also have been working on a novel, Brad. I know you are aware of it, and The Judgment Line, and it's got nothing to do with the fire department. It's all kind of lawyer, kind of, yeah, it's up in the clouds, but it's called The Judgment Line. But hopefully, we'll be taking pre-orders sometime over the next couple of weeks, and it'll be published later in the spring. So we'll see how it goes. I guess
Just proving that Curt sleeps 1 hour a day.
yeah. No, I think you've got more energy than me, but but I think we run on the same batteries. So, all right, man, and that is going to do it for another edition of Fire Law Roundup, and we'll see you.